I would like to talk a little bit about my perspective on, as the question you posed to us over email, Terry, asked, Maunakea in relationship to the 30-meter telescope, proposed construction, and also astronomy in general. I think it's important to note from the very beginning that the kind of techno-scientific network that has been built at Maunakea is very diffuse, as in, like Hilding said, there are multinational kind of consortiums that have been putting in money for this project, and this is consistent with many of the observatories already built at Maunakea. And these observatories are in many kind of dominant understandings of astronomy and astrophysics, scientific pursuits that use technological instrumentation that's really advanced for scientific inquiry in these fields, right? And so there's a lot of moving parts in this network, right? There's actual complexes with instrumentation, with different kinds of instrumentation, not just telescopes, and there are different kinds of telescopes, radio telescopes, infrared optical telescopes. Currently, there are 13 observatories at the summit region of Maunakea in the what's now called the Maunakea Science Reserve, and it's also labeled in a sub-designation an astronomy precinct in what the state of Hawaii has regulated now as a conservation district. And so there's an astronomy precinct in a conservation district that is labeled a Maunakea Science Reserve. And so I just want to say that to kind of preface my comments, because it's a little bit cacophonous and sort of confusing for folks that haven't been to Hawaii, don't know about this issue, haven't been to Maunakea. There are a lot of moving parts that I think are important to just ground folks on. So my perspective that I'd like to share tonight is this, and I'll talk a little bit about how it's evolved in this process. And I'll try my best to be brief. The 30-meter telescope, in my expert opinion, should not be built at TMT for 5 primary reasons. The first one is that Maunakea is overdeveloped. As I mentioned, there are already 21 telescopes and 13 observatories at Maunakea. There's a student telescope that's being proposed to be built currently. And like Hilding said, there have been other telescope add-ons that have been proposed and failed. And as we know, well, many of us know, the Canadian long-range plan has ranked the renovation of the Canada-France-Hawaii telescope high in its facility recommendation. So there's already a Canadian complex that is currently on Maunakea at the summit region. And this overdevelopment at Maunakea has actually come into a bit of a set of problems. And one of the sets of problems is that when these telescope observatories are proposed, they're also mandated to craft decommissioning protocol. And so there are some telescopes that are in their decommissioning protocol that actually, because of pollution, cannot match and meet and satisfy their decommissioning protocols and timelines. So the telescope observatory I'm thinking about is the Caltech submillimeter telescope, which had a hydraulic fluid leak in its instrumentation and polluted its own concrete foundation, which complicated its decommissioning process. And so that telescope, which is sort of told is in decommissioning protocol, is not able to actually decommission in the timeline that it was proposed to. And so these projects of massive and small scale telescope observatories have environmental consequences that keep them from actually decommissioning, you know, really satisfying their own mandates, if you will. And so what in turn has happened is that development in the science reserve has actually already made a substantial and adverse impact on Maunakea's natural resources. And so this means that Maunakea's environmental resources and cultural resources, and this is sort of legal language from the state of Hawaii and court cases and decisions about the building permit in specific I'm thinking about. And so recently in 2018, as Hilding mentioned, the Supreme Court of the state of Hawaii ruled that the conservation district use permit by the University of Hawaii applying on behalf of the 30-meter International Telescope Corporation, because the University of Hawaii holds the master lease on the Maunakea Science Reserve land from the state of Hawaii. So it has to apply for subleases on behalf of these corporations. So in 2018, the Supreme Court of Hawaii ruled in favor of UH and the TIO in authorizing its conservation district use permit. But I want to highlight one sort of tension that has gone without highlighting. In the majority opinion written by the court uses what's called a degradation principle to assert that there's already been an adverse significant impact on natural resources at Mauna Kea, so that Mauna Kea has been degraded previously, so much so that building the 30-meter telescope, which this conservation district use permit is applying for, would not cause the substantial adverse impact to natural resources. And so that's the justification that the majority opinion gave. However, in the dissenting opinion, the court argues against this degradation principle that essentially says it contravenes environmental norms, principles, and law, to suggest that in a conservation district, development that had previously accumulated substantial adverse impacts to natural resources would actually become a rationale to degrade those natural resources further. So the dissenting opinion was written by Justice Wilson in 2018, and it's gone slightly unhighlighted for obvious reasons in dominant discourse, but he highlights this really important point that it's akin to a rapacious logic of, if an environment has been harmed and degraded so much in the past that it's okay to harm and degrade it more, right? And I emphasize the rapacious nature of this logic, because what Justice Wilson is actually trying to get us to think about as well is the way in which that this can circulate as a kind of rape logic, right? That to harm someone in the past does not and should not ethically and morally and legally, according to state law in his argument, condone harming them further. And so I want to highlight that that's the kind of situation of how Mauna Kea is overdeveloped. Previously, it actually, by the territorial government in 1901, I believe, it was geographically marked a wasteland. And now the hyper-industrialization continues via this kind of degradation logic that Justice Wilson was showing us. So the second reason why I think TMT shouldn't be built, in my sort of expert perspective on this, as somebody who's been writing and researching astronomy industry development at Mauna Kea for some time now, is that Mauna Kea, the science reserve, is incredibly mismanaged. So I already kind of noted about how the University of Hawaii has the master lease over the Mauna Kea Science Reserve, and the Board of Land and Natural Resources regulates that master lease and the Mauna Kea Science Reserve. So these two one a state agency and one a public university in the state of Hawaii, are severely mismanaging the Mauna Kea Science Reserve. And that should be a concern for everyone, astronomers, local people in Hawaii, on Hawaii Island, and Kanaka Maoli Native Hawaiians alike. So in 1998 and 2005, there was a legislative audit of these two organizations that found severe mismanagement problems. over the natural resources at Maunakea. And actually in 1997, there was an independent assessment of the TMT project. So before 2000, the Betty and Gordon Moore Foundation contracted with the Keystone Institute, which is based out of Colorado, to do a risk assessment of the TMT being sited at Maunakea. And the report in 1997, paid for by the Gordon and Betty Moore Foundation, actually suggested that there was legal confusion, bureaucratic ambiguity, and a vacuum in leadership, all related to the ways in which the state and the University of Hawaii have become entangled in this mess that even today, they're trying to create and implement rules to satisfy an audit that happened 15 years ago. And so what this has resulted in is a bevy of lawsuits, as Hilding pointed out, and two in particular that I want to highlight, which are really important and are still pending and waiting decisions currently, which adds to the level of inauthority the state has to pursue this project currently and in the near future. The first lawsuit is by the Office of Hawaiian Affairs, and they've just recently this year in March asked for a summary judgment on this case, which hasn't come from the judge. And the lawsuit alleges that the state has failed to manage the ceded lands that the Maunakea Science Reserve sits on at Maunakea, right? So there's a lot of like topographical jurisdictions that I'm talking about. And so I'm trying to track that for you all to kind of understand. But Maunakea is a part of the Ceded Lands Trust that the state of Hawaii manages as a public land trust. And I'll talk a little bit about what that means in a second. So OHA's filing a lawsuit saying that the state has failed its trust responsibility in these ceded lands. The second lawsuit is by a few cultural practitioners represented by the Native Hawaiian Legal Corporation, and it's a lawsuit over the state and the Department of Hawaiian Homeland's mismanagement of Mauna Kea's access road, actually. And it zeroes in on the access road because this is where a police barricade was erected and then a blockade of Indigenous elders of Hawaii, or as we call in our language, kupuna. And so a lot of people don't know that there was actually a police barricade behind our blockade at Mauna Kea Access Road. And so we, as Kanaka Maoli, weren't allowed to access past the police barricade. And that's typically not talked about a lot in the public discourse still. Nevertheless, this lawsuit alleges that the state, despite building a road, Mauna Kea Access Road, on Hawaiian homelands, did not actually satisfy the contractual obligations to acquire the land beneath the road. So the land beneath the road did not get legally transferred to the Department of Transportation in the state of Hawaii to build the road on top of that land. And so the jurisdiction over Mauna Kea Access Road is being adjudicated in this lawsuit, which is incredibly important for thinking about these 33 arrests of our Indigenous elders, right? All Native Hawaiian beneficiaries of the Department of Hawaiian Homelands who have a right to their Hawaiian land in federal legal statute. And so this is a case that we should follow very astutely, but also the OHA case as well. The third reason is that Mauna Kea is seized land, not ceded land. There's a reason why the title of this conversation is referencing how Mauna Kea is unceded territory. I think this is something that in Canadian sort of dominant discourse you hear, especially when considering what has been taking place at the unceded territory at Wet'suwet'en. Also thinking about other sorts of territorial struggles on unceded land, Sekapwemic, and also what's taking place in Caledonia right now with 1492 land back lane and Six Nations Haudenosaunee claims to land that a housing developer is attempting to build on. So unceded territory is also a thing in Hawaii. And I want to explain it just as fast as I can. The astronomy precinct is in the Maunakea Science Reserve, and that's sitting on the ceded lands that the state manages. Well, those ceded lands were actually illegally seized and stolen from the Hawaiian Kingdom's government and Kanaka Maoli people in the late 19th century. This was territory that belonged to the crown of the Hawaiian Kingdom's constitutional monarchy. It was called Crown Land. It's actually called King's Land before. And then later, when a white Euro-American oligarchy of businessmen, lawyers, and capitalists that were attempting to really pounce on the trade of sugar and then later pineapple, they overthrew the Hawaiian Kingdom's government and infiltrated its state apparatus. They called themselves the Provisional Government, then the Republic of Hawaii, when Grover Cleveland refused to acknowledge they were a legitimate government. And in doing so, they also usurped the national lands of the Hawaiian Kingdom, including the crown lands and the government lands, which is about 2 million acres of territory in Hawaii. And so this white Euro-American republic appealed to the US federal government to be incorporated, which later President William McKinley did, needing a coaling station in the Pacific to fight in Guam and the Philippines in the Spanish-American War. So although in 1897, a treaty was never ratified by Senate, right? There's never been a treaty of annexation that's actually been ratified by the Senate. It failed in 1897. Congress passed a joint resolution, a domestic piece of legislation to annex Hawaii, which international legal experts say does not have authority to do. It, as Keanu Sai, who's an international legal expert and indigenous politics professor, says, it would be like Great Britain trying to annex the United States, or the United States trying to annex Japan through a domestic piece of legislation, which is what happened in the late 19th century. And so those lands were then transferred by the white Euro-American government to the federal government, which then in the middle of the 20th century created the state of Hawaii and delegated its management of the 2 million acres. And then the state of Hawaii created the Maunakea Science Reserve. And now you see where I'm going, that Maunakea is unceded territory. It was seized but not ceded by the Hawaiian Kingdom's government and the Hawaiian people. And actually, this has been affirmed in public law signed by former President Bill Clinton in this apology resolution, where he says that the indigenous people of Hawaii have never relinquished their territorial sovereignty over their national lands including Maunakea. There's also no indigenous consent beyond the kind of lack of relinquishing title and authority over national lands to the occupying government, to the US, and to now the state of Hawaii. You know, opposition against TMT uses these national claims to territory, saying that Maunakea is unceded land. But also, in 2019, the United Nations Committee on the Elimination of Racial Discrimination penned a letter to the state of Hawaii and the US rapporteur for that committee that recognized there is no free, prior, informed consent that's been obtained from indigenous people of Hawaii for TMT. So at an international level, the United Nations is investigating this matter, recognizing that consent by the people hasn't been obtained. Recently, there have been quite a number of polls and surveys that have attempted to suggest that Native Hawaiians or the people of Hawaii support TMT at Maunakea. And in fact, a 2019 December survey refuted those polls and their claims. A group of HPU researchers with a Native Hawaiian survey polled about 1,000 Native Hawaiians, self-identified Native Hawaiians, which was a much larger sample size than former polls that were sponsored by the TIO and done in the state of Hawaii had, and asked participants, Native Hawaiian participants, if they support the 30-meter telescope at Maunakea. And so this HPU survey result came back and showed 88% of Native Hawaiians surveyed do not support the 30-meter telescope. This is an incredible poll because it not only refutes the former polls, but it also asks specifically Native Hawaiians and Native Hawaiians from Hawaii Island, from the Big Island, that are most directly affected by astronomy industry development. So it's an incredible poll to pay attention to. And lastly, on this point, some will say that, oh, well, in 2009, the Office of Foreign Affairs, which is a state agency that was created from a constitutional convention in 1978, it has 20% of the revenues and sale monies from the Ceded Lands Trust allocated to it for the betterment of Native Hawaiians. This is the Office of Hawaiian Affairs. It's sort of our representative body, but it's still a state body. The Office of Hawaiian Affairs supported the siting of TMT at Maunakea. And so a lot of astronomers and a lot of folks look to that resolution to suggest that consent was obtained, that the Office of Hawaiian Affairs provided consent. It's a legitimate, recognizable political body that represents Native Hawaiians, and it consented to the siting of Maunakea. Well, consent can change. In 2015, after a wave of vigils and opposition in 2014, stopping the groundbreaking ceremony, creating a bit of infrastructure at Hale Pohaku, the Maunakea Visitor Center, to stop TMT construction crews, the Office of Hawaiian Affairs listened and changed their mind and actually passed, without opposition, a resolution that rescinded its support. So currently, the Office of Hawaiian Affairs does not support the 30-meter telescope at Maunakea, and recently publicly corrected a TMT advisory committee called CATAC here in the Canadian astronomy context for suggesting that the Office of Hawaiian Affairs currently supports TMT. And in refutation, suggested to not only the CATAC committee, but also Acura and CASCA, that the record be set straight and that it be shown that the Office of Hawaiian Affairs does not support TMT's siting at Maunakea at the Northern Plateau. And I think this is really important for us to think about because there are serious consequences for this kind of action by the Canadian astronomy community, consequences for violations of the UN Declaration on the Rights of Indigenous Peoples, particularly Article 8, which is about propaganda, trying to influence a community about another community, particularly an Indigenous community, and Article 32, which is about development and free, prior, and informed consent. These declarations, these articles from UNDRIP should be taken seriously, not just in jest and in gesture, but in reality, because they affect not just Indigenous people, but they affect other people as well. So the last thing I'll say, and then I'll turn it over, I know this wasn't very brief, I tried, is that the TMT will require, in order to be built at Maunakea, it will require further police and military force. The long-range plans, facility recommendations suggested that it would not condone force to build facilities that Canada is invested in. And I want to stress this point because in order for TMT to be built, more police and military force will be required. On July 17th, 2019, about a year ago, I saw firsthand how the state, its police, the US military, through the Army National Guard, engaged Kanaka Maoli. I was there when 33 elders were arrested. I was there on the side of Maunakea Access Road as my people were detained and thrown into paddy wagons, but not just any people, elders. Some were 90 years old and in wheelchairs. Police had to wheel my relatives into paddy wagons. This is the engagement that the state is willing to perform to open Maunakea Access Road and to allow TMT to be built. And It would require more riot batons. It would require tactical gear. It would require a sound cannon, which was directly in front of my face. I don't know if you've ever seen a sound cannon in person, but this one was actually very sophisticated and it's much smaller than I imagined. But with one twist of a knob, your eardrums could be blown. It could be very, very dangerous and harmful. They arrested 33 of our elders that day, and I saw, but they also threatened to come down harder in months later. This is a story that most people have read about, have heard about, but haven't felt. And it's important to note those feelings even now, a year and a half later, because astronomy, Canadian astronomy, shouldn't require the arresting of Indigenous elders, shouldn't require a sound cannon to answer research questions about exoplanets. We should be concerned about life on our planet. And in particular, in a state and nation like Canada, we should be concerned about reconciling with Indigenous peoples, and that police and military violence is not reconciliation. I'll stop there.